The designated hour having arrived, I call to order this regular meeting of Ansel Klink's Quorum Forum podcast, the podcast local governments need to do business in. The chair, it's me, Daniel J. Bolin. On the agenda today, it's recent Supreme Court decisions impacting community development, recorded live. The APA, American Planning Association, Illinois State Section, Spring Planning Conference. But first, let's take the roll. Behind the glass for our protection engineer, Rick, is present. We have a quorum. Dear listener, how can decisions issued by the nation's highest court impact community development at the local level? Well, we're going to find out today with Megan Mack and Aaron Monforti as they joined the APA Illinois State Section Spring Planning Conference to discuss two recent U.S. Supreme Court decisions, the City of Grants Pass versus Johnson and Sheets versus the County of El Dorado, moderated by the City of Champaign Planning Manager Jeff Marino. This session discussed how planners and local governments are responding to these recent decisions involving public camping and development impact fees. These cases, we've mentioned them on the podcast before, some of them at least, especially the Grants Pass case. Local governments are still grappling with the impacts of this decision from last year, and state legislatures are responding to it too in Illinois, and we're looking at what this means for local governments, planners at the Illinois State Section of the American Planning Association. We're interested to hear about it very recently, and we were fortunate that we recorded it for Ansel Klink's Quorum Forum podcast. So, without further ado, Engineer Rick, roll it.
I'm Megan Mack, and I'm joined with Aaron Monforti. We're both attorneys with Ansel Klink. Thank you so much for having us. This episode is being recorded by Quorum Forum. Hopefully you've heard of Ansel Klink and you've heard of our podcast Quorum Forum before. We are super excited to be talking to you today. Hopefully you'll take back some of the knowledge you have. I just learned several things in the trivia. I realized that the only thing I knew was related to Wilco, and that was kind of sad. So before we get started, we just want to do a few quick plugs, as we always do when we start talking about Ansel Klink. We want to let you know, though, that we have a lot of free resources for you. Ansel Klink One is one of the oldest law firms in Illinois. We are very well known for writing the Illinois Municipal League Handbook. It's an amazing resource, but you do need to pay for that. So I want to tell you about several of our free resources that we are going to encourage you to subscribe to. Our website, which is new, if you haven't had a chance to check it out lately, you'll see that our pictures are updated to reflect what we currently look like and not the 8-year-old versions of us that were there until a few months ago. So we have a blog that's called Municipal Minute. It has it posts several times a week. It's not daily, but we get pretty close to it. We talk about issues related to local government, often case law updates, legislation. We do a lot of land use and zoning related issues as well. You can subscribe to it, and every time there's a new blog, it'll come to your email. We also do a zoning and land use publication called In the Zone. That I think comes out about twice a year now. That's focused for this group for sure. It's land use and development cases and topics. And lastly, as you're going to be participating in, is our podcast Quorum Forum. You can find this wherever you download podcasts, and a new podcast usually airs about once a month. This presentation, like I said, will eventually air on that. So if you have any questions, they will be part of it. You can go to the next slide, Aaron. Thank you. As a disclaimer, because if we wouldn't be lawyers if we didn't have a disclaimer on the screen, we want to remind you today that we're going to talk to you about some case law, specifically some recent cases that have come from the U.S. Supreme Court and our interpretation of those cases, as well as some legislation and what we think that legislation will mean. However, we want you to engage it and ask us questions, throw questions into the chat. We hope this results in some meaningful dialogue. But we do want to note that this presentation is not meant to be legal advice. And as always, you should consult with your municipal attorney on any issues that are related to your community. Additional disclaimer, I always script my presentations, but I tend to not follow them. Erin is much better at that than I am, so please bear with me. I'm sure I'm going to continue to go off script as I already have. I am absolutely horrible at sticking to my notes. So with that, Erin, please, next slide. And we're going to dive right in. The first case we're talking about today is the City of Grants Pass in Oregon versus Johnson. This is a Supreme Court case that was decided in June of 2024. It's actually a case that we were waiting for the Supreme Court to decide on for quite a while, especially as at Enacted we represent a lot of park districts who were waiting to see what this case meant. It has to do with public camping. It also has to do with homelessness. The second case that we're going to talk about today is the Sheets case. Erin's going to focus more on that case, and that case focuses on constitutional issues that are related to impact fees. But going back to Grants Pass, this is the Supreme Court's ruling on an anti-camping ordinance as it relates to the Eighth Amendment, which deals with cruel and unusual punishment. And so I'm going to get started by going through for you the legal background, the contents of the decision, and local government's response. And in the end, we'll get to some proposed legislation and also some proposed ordinances that the Illinois Municipal League has crafted. So before getting into the actual Grants Pass case, it's really important that we do talk about the case that really led up to the Grants Pass decision, and that's a case called Martin v. City of Boise. And for those of you that are more familiar with case law, the Ninth Circuit is where we get a lot of our crazier decisions. And so the Ninth Circuit made a decision in the Martin case that the Eighth Amendment prevents cities from enforcing criminal restrictions on public camping unless the person has access to adequate temporary shelter. And so to give you a little background about what was going on in that case, the city of Boise was dealing with a lot of homeless related issues. And so they enacted ordinances that made it a misdemeanor to use streets, sidewalks, parks, or public places for camping. And what they were doing is they were essentially deciding that when there were places in homeless shelters and that the homeless people were not taking advantage of those places, that meant they were not using the availability of these shelters for them, and they were issuing misdemeanor tickets. You can imagine how impractical it was to try and enforce the numbers game that related to this, the counting that these communities had to do. First, to count the number of homeless people that would have been on the street on any given night versus the number of beds that were given at any available shelter. And they tried. What they ended up doing was having shelters report to them when they got to full capacity. Well, there were three main shelters in Boise, and one took males, children, and women. Another one took just women and children. Another one took men. However, these shelters, two of them had some religious denominations and had some criteria related to them as well. That, for example, after 17 nights and staying with them, you then had to commit to more of a religious type of living. And so the court actually said that oops, I'm sorry, I skipped ahead of my notes. That wasn't a practical way to enforce or to address the homeless situation that was going on. And the Ninth Circuit said that because 3/4 of Boise shelter beds were not practically available because the city's charitable shelters had a religious atmosphere, that Boise was prohibited from enforcing its camping laws against the plaintiffs in that case. So it didn't matter that even though the shelters had adequate space and that people were not availing themselves to that they decided that was not appropriate relief and it was unconstitutional. You can go ahead. Thank you. So the next case that comes along is Grants Pass. And Grants Pass is in Oregon. It's home to roughly 38,000 people. About 600 of are estimated to experience homelessness on any given day. They enacted 3 ordinances in response to the homeless problems that they were experiencing. And these laws specifically included one that prohibited sleeping on public sidewalks, streets, and alleyways, another that prohibited camping on public property, and a third that prohibited camping and overnight parking in city parks. They defined camping as setting up or remaining in or at a campsite. And then they defined a campsite as any place where bedding, sleeping bags, or other material for bedding purposes or any stove or fire is placed for the purpose of maintaining a temporary place to live. The penalties then for violating these ordinances were on an escalating scale. So while your initial violation could trigger maybe just a small fine, an individual who was then cited multiple times could then be barred from the city parks for 30 days. And then after that, you could then be cited with criminal trespass. You could also be cited with disorderly conduct. You could be in prison for up to 30 days, and you could also face a fine of up to $1,250 for each violation. You can go to the next slide, Erin. Thank you. So 2 individuals decided to bring a case, one of them whose last name was Johnson, against the city of Grants Pass. And they challenged the city's anti-camping ordinances unconstitutional under the 8th Amendment. And the 8th Amendment specifically says excessive bail shall not be required, excessive fines shall not be imposed, and unusual punishment not inflicted. And so I think we tend to think when we think unusual, cruel and unusual punishment, and the Supreme Court even starts to address this in the case, is we tend to think of cruel and unusual punishment as going back to the days of where we would hang people or we would burn people. But it does have larger implications, and believe it or not, we do get 8th Amendment challenges, and they're more common than we think of. We still talk about things being, the fine or the punishment not being appropriate for what the offense is, and so that's essentially what their argument was. The district court had actually prohibited the city of Grants Pass from enforcing this because they applied that Martin v. Boise test. And the court found that individuals in Grants Pass were essentially involuntarily homeless because the city's total homeless population exceeded the practically available shelter beds under Martin. And so they affirmed the lower court's position. And you start hearing the term Martin injunction be thrown around. So I talked first about the Martin case, Martin v. Boise. And so now Martin injunction starts getting thrown around, especially around the 9th Circuit states, which are, the California, Idaho, Oregon, that area. Martin injunction starts to paralyze efforts of communities where the local governments were taking efforts to kind of solve their homeless problems and try and get effective solutions for their homeless issues while protecting their community's right to safely enjoy public spaces. So we have, different issues and balancing what are the rights to homeless people to safely camp out in parks when they have nowhere else to stay, but also we're balancing the issue of the safety of everyone else in the community if we have these large populations of tents now because we have such large numbers of homeless people. And after the Martin case came out, we had a huge fear of local governments, especially from wanting to take steps to help with the homeless population and try and take away essentially these like tent cities and try and move people towards not forcing them to take advantage of homeless shelters, but encouraging people to take advantage of homeless shelters for fear of getting slapped with what was being referred to as a Martin injunction. So
I think, sorry, Megan, I just want to jump in there. I think what's interesting is, and we'll get to the actual Supreme Court opinion in just the next few minutes, but one thing that nowadays it's very rare, and actually the case I'll be talking today was a unanimous decision, but it's very rare to see the justices align on certain, even the most like foundational, fundamental policy issues. But I think what was interesting in Grants Pass is that the justices did align on one thing, which is the policy making function of local government, the issues that are facing local governments related to unhoused people are significant. And I thought that was an interesting kind of, even though obviously the majority opinion and the dissent came to different answers in the case, they both agreed that this is obviously both like through empirical data about homeless people in the United States, and then some of the policy issues we've seen crop up in the last few years. This is a big issue, which of course isn't news to any of our attendees today.
Absolutely. Thank you for jumping in, actually, and please continue to. If you want to go to the next slide. So we've been talking about this case actually for several years, believe it or not. And what we were talking about before the Supreme Court weighed in is that we were encouraging our clients to move away from anti-camping ordinances, telling them that under Martin and under the most recent appellate court decision in Grants Pass, that they could not make anti-camping laws, and they couldn't enforce criminal anti-camping laws. And we were hoping the Supreme Court was going to take up this case and the Supreme Court would weigh in, and they did. And there were a lot of amicus briefs filed, and as Aaron just said, we got some very interesting opinion that came in this case, and we got some very interesting dialogue from the Supreme Court. And the result that we got was the Supreme Court essentially gave us an opinion. It is somewhat limited, and we're going to spend some time talking to you about that. But essentially what the Supreme Court said is that anti-camping ordinances do not violate the Eighth Amendment. Anti-camping ordinances that criminalize anti-camping or things related to anti-camping type behaviors are not in itself cruel and unusual punishment, and that was the majority opinion. And Justice Sotomayor gave a dissenting opinion, and her rationale is very interesting too. So I think I'm on slide 9, right? Okay, so in the majority opinion, the majority spends a lot of time talking about the fact that it's not the act of being homeless itself that's being criminalized. It is the fact that local governments are trying to just address the behavior related with camping outdoors and camping in public parks. That it is the ordinance and the classification of ordinances that are being applied for people that violate these are being addressed along the same lines to everybody, and that the ordinances are not criminalizing the status of being homeless itself, that they're just criminalizing the conduct. And they spend a lot of time talking about the two cases that that most historically address whether or not we can criminalize status versus conduct. And the case that has most often been discussed is a case called Robinson v. California. And this is a case where, going back, the state of California tried to criminalize the act of being an addict. And back then, the Supreme Court said, no, you can't do that. You can criminalize behaviors that go along with drug addiction. You can criminalize, for example, possession of drugs. You can criminalize being under the influence of drugs. However, you cannot criminalize the status of being an addict. There's another case too called Powell, that a case that came out of Texas, where the state actually was criminalizing someone for being under the influence of alcohol in public, and the Supreme Court said that's okay. Again, now you're criminalizing the conduct of somebody who's being drunk in public. You aren't criminalizing the behavior of somebody just for being an alcoholic. And you can see how there's a fine line between some of these arguments. And the Supreme Court kind of gets in the weeds on a lot of these arguments, and you see them intertwined between both the majority opinion and the dissent. But essentially, and I told you I was going to go off script, and there I did, true to my word. But the Supreme Court's holding, and it's one that we are advising all of our clients on now until there's some Illinois legislation we'll get to a little bit later that may flip the script on this, is that it is not cruel and unusual punishment. It does not violate the Eighth Amendment if you want to enact anti-camping laws. And because you are not actually punishing someone because of their housing status, it makes no difference whether someone is a person who is experiencing homelessness, they're a backpacker on vacation, they happen to be a student who abandoned their dorm room to camp out in protest on the lawn of a municipal building. They're all subject to the same penalties. Erin, do you want to jump in?
Oh, no, I think that's a great point, though, about status and how that kind of really wove itself into the Supreme Court's both the majority and dissenting opinion. And I think the Robinson case is a great example of how that might apply. If you can't criminalize the status of being, having substance use disorders or whatever, but you can criminalize possession, use of drugs. And I think that the analysis and the analogies drawn by the court are really interesting here.
And the same goes for mental health issues as well. Mm-hmm. And they're going to be things that we are going to have to continue to address as units of local government and just as society. If you want to go to the next slide. So Justice Sotomayor's dissenting opinion is also really well written and also very interesting. And she said in hers that she absolutely disagreed that the ordinance was 100% based on status. And she used an example that infants napping in strollers and nighttime stargazers would have been exempt from the punishment under these ordinances because they have separate places to live, which means they're presumably intended to return to somewhere else. And the result of this ordinance criminalizes someone for the status of being homeless, and all people essentially need to sleep. And if you have a chance, I think it's worth a read of her dissent, because I think she does a really good job of advocating on behalf of the homeless population. Is to essentially, she talks about the fact that you're saying to someone who has nowhere to live that the second they stop moving and they happen to be in a park, they've now committed a crime. So if you want to move on to the next slide. What we do need to focus on, though, is that the court did take the time to point out to other legal doctrines and constitutional protections that would apply. They also discussed the defenses of necessity, insanity, and diminished capacity and duress. States and cities may also add their own substantive protections. Since this litigation began, Oregon has adopted laws specifically addressing how far municipalities may go in regulating public camping. We also need to talk about, is an individual involuntarily homeless and whether a shelter is practically available, because that's not found anywhere in the cruel and unusual punishments clause. The Martin involuntariness test creates uncertainty for cities because it takes away the power of the elected leaders to answer some of those difficult questions. And that was what we were struggling with before the Supreme Court heard this case. Is we had communities that wanted to do something to help with the homeless issues in their community, but they felt that they were going to get slapped with injunctions and litigation if they did. So what we need to focus on is this is a narrow ruling, that the Eighth Amendment was not implicated by enforcing anti-camping ordinances against individuals experiencing homelessness, that anti-camping ordinances could violate other parts of the Constitution, like excessive fine and then due process clauses. If you want to go on to the next slide. The thing we also need to take into account in Illinois is that Illinois has additional protections. So in 1979, Illinois adopted the Illinois Human Rights Act, which prohibits discrimination under state law for the same categories as the Federal Civil Rights Act. Additional protected classes were added over the years, and this includes prohibition on discrimination on the basis of ancestry, physical or mental disability, access to financial credit, and the availability of public accommodations. It's a civil rights violation for a public official to deny or refuse the full and equal enjoyment of accommodations, advantage, facilities, or privileges of the official's office or service, or of any property under the official's care because of unlawful discrimination. A place of public accommodation includes places of lodging, public gathering, public transportation stations, and parks or other places of recreation. The Illinois Bill of Rights for the Homeless Act was passed in 2013. It provides specific protections for homeless populations in addition to various state and federal constitution protections. It specifically prohibits discrimination based on housing status and defines what municipalities can and can't do with how they handle their homeless populations. Some of the important protections include the right to use and move freely in public spaces, including but not limited to public sidewalks, public parks, public transportation, public buildings, the right to equal treatment by all states and municipal agencies, the right to reasonable expectation of privacy in his or her personal property. And this comes up a lot. I can't really think of a lot of occasions where you're actually removing a homeless person from a public park and they don't have things and belongings with them. So what do you do then with those belongings? And those are real things that units of government and enforcing agencies have to think about is, if their person is not able to take those things with them, then what are your responsibilities as a unit of local government? There are several cases out of the city of Chicago where the city was in trouble from removing, and I think that some of these had to do with the movement at Lower Wacker Drive, but the homeless populations, if they're being moved, their articles have to be preserved. Now, these are Chicago cases. They don't necessarily have any authority over the rest of the state, but they're good for thinking about, well, the courts have said this in these cases. What is that likely to mean in my community? It's always kind of been our interpretation that these cases mean that you cannot, one, just throw away the belongings of a homeless person if you are to move them, that they have the right to access their belongings after they're moved. There's no answer to how long it is you have to hold these belongings or what you need to do. But I would say you have to give them a reasonable time to gather them after they've been moved, whether or not they were taken to a hospital, whether they were moved to a temporary shelter, or if they were incarcerated. You have to give them the opportunity to come back and collect these. I would say 48 hours at a minimum sounds reasonable to me. You definitely cannot just take their items and throw them in the garbage. There's a right to keep one's job. There's a right to access to emergency medical care and the right to vote. I think I'm on slide 13. You know me, I went off script again. The Illinois Trust Act also plays in here. The Illinois Trust Act declared that federal government has the sole authority to enforce immigration laws. Local police departments can still enforce other laws against individuals who violate other municipal ordinances or state laws, but they cannot detain or arrest migrants solely based on their immigration status. We've obviously all been well-versed in the last couple of months about the Illinois Trust Act. And then we're getting closer to the end in our last couple of slides. This is some new legislation, House Bill 1429. It was introduced January of this year. It amends the Bill of Rights for the Homeless Act. Essentially, this legislation, it's still in the House, but I checked on it the other day. It's gathering a lot of support. I'm not sure where it'll go, but I suspect if it doesn't go anywhere this session, we'll see it come back because it's getting so much support. But right now, it would essentially make and it refers to local governments and I guess park districts as enforcing entities, that any enforcing entity that seeks to move a homeless person or anyone who's camping, it requires notice. It says that notice has to be conspicuous. It has to be given 7 days before you're to remove somebody from a site. You have to give them written notice. You also, if you simultaneously are at the same place and time as the person you seek to move, you have to give them in-person notice. You have to do that before moving a person unless there's an imminent risk to public health and safety. And public health and safety for emergency has to do with public access to property or public health and safety measures. I'm trying to struggle to think of kind of what those are. we in-house have kind of talked about what does that mean if there happens to be homeless people camped out in the middle of a soccer field and we're trying to start a soccer game. I guess according to this legislation as it's currently written, we would have to give them a written notice that they can't be camped there. They're violating our anti-camping ordinances, but we'd have to wait a 7-day period because I can't think of how that would be an imminent risk to public health or safety. We'd have to tell them if we had contact with them and then wait 7 days to physically move that tent encampment from that soccer field. The legislation states that in determining whether an actual emergency exists, this is the last slide, that the enforcing entity shall declare an emergency only when there's an imminent risk to individuals or community members that can be mitigated by requiring unsheltered individuals to move themselves or their belongings. And in both emergency and non-emergency cases, the enforcing agency shall make good faith efforts to provide transportation, refer to social services and other resources to remedy their immediate shelter and long-term housing needs. So I think there's some good intents in, I like all of the suggestions about, providing service and things like that. I think the notice is going to be something communities struggle with. I'm sorry, I do have one more slide. In response to the grants pass legislation, or I'm sorry, the grants pass decision, the Illinois Municipal League did come out with a model ordinance. The model ordinance contains multiple explicit references to the homelessness crisis in Illinois, making it clear that the legislative intent is to prohibit public camping by homeless individuals. A lot of municipalities have ordinances that do impose civil penalties for camping activity on public property. IML's ordinance also imposes possible criminal penalties with up to 6 months incarceration. We just want to remind you that singling out homeless persons for extraordinary criminal penalties could expose your municipal corporations to claims under the Illinois Human Rights Act, the Illinois Civil Rights Act, the Illinois Bill of Rights for the Homeless Act, and then other constitutional challenges. And just remind you that grants pass was strictly limited to a challenge based on the 8th Amendment. The opinion itself recognizes that state law can limit how far municipalities can go in regulating public camping. And with that, I am going to turn it over to Erin, who's going to talk to you about the Sheets case and the Habdad case.
Thanks, Megan. This picture makes me want to, I think it's a little late for spring break, I guess, but I enjoyed both of the photos we pulled from the West Coast in California and Oregon for these cases. So as Megan mentioned, the second issue we're going to address today is the, imposition of impact fees for development and how that intersects with Supreme Court takings case law. And so, if you took a land use law class when you were studying planning or maybe at the undergrad level, it's likely you explored a couple of the cases we'll be talking about today. It helps that they rhyme, Nollan and Dolan. I always think that's a helpful little trick of the mind when you're thinking of these issues. And the reason that, and I think Megan's presentation primed us for this kind of analysis we're going to do today. Before we get into Sheets, we do have to talk about the cases that came before, because there are some really fundamental takings issues under the 5th Amendment and the 14th Amendment that have been developing in the court at the court's analysis since the late 80s. So it's been a long time coming. And Sheets is just the most recent step in this analysis. So like I said, this is a photo. Our listeners on Quorum Forum won't be able to see it, but you can imagine it. This is a photo of El Dorado County in California. And what's interesting about it is that much of the county is public land. I did some quick, nice Wikipedia work on this, and 43% of the land in the county is public. So I think that's pretty incredible. It's home to part of Lake Tahoe. There are a ton of national and state parks in this area of the state, and it's right in the crook of the elbow of California on the east side. So if you can imagine that kind of very sharp angle that it takes, it's right there where that angle is on the East Coast. So some helpful background. So this is part of the Fifth Amendment. The full Fifth Amendment is a few more lines about different issues as well. But the key issue we're going to be looking at today is the takings provision of the Fifth Amendment. So, nor shall private property be taken for public use without just compensation. And for a very long time, from the founding until after the Civil War, the Fifth Amendment was presumed to only apply between the federal government and individuals. So if you think about why the Constitution was ratified, the Bill of Rights was ratified, it was to protect individuals from overreach of government. And so at the time, the federalism issues and other things were quite different. So after the Civil War, during the Reconstruction era, they passed the 13th, 14th, and 5th Amendment, and 15th Amendments. And the 14th Amendment basically says, the Fifth Amendment, including the takings regulations, apply between individuals and state governments. So it kind of took it from the federal level and brought it down to the state level. So takings, again, if you've taken a land use law class or did any law work in your studies, you know that the history of takings law is long and complicated. And the justification for requiring just compensation when government takes your land is that, the Supreme Court has ruled that it's inappropriate for individual citizens to bear a burden that should be borne by society as a whole. So if you're thinking about, if you took someone's property to build a public park, if you just sort of kicked them out and decided you were going to put a park there, the park would benefit the entire community, but you're depriving one property owner of, their rights and to enjoy their property, to exclude others, etc. So the takings clause recognizes that that's, a huge intrusion on liberty in kind of a traditional sense, and that the government should be compensating folks when their property is taken. So the most extreme cases involving takings are those physical takings. So if you've kind of delved into the case law on this at all, there are cases that say, even the smallest intrusion physically on someone's property is a taking. So there's a case involving utility poles, which don't take up, they're tall, but they don't take up a lot of square footage on someone's land usually. The Supreme Court has ruled that even such a small area of someone's land, if the government takes it without just compensation, that's a violation of the Constitution. So those are physical takings. It's kind of easy to imagine a physical invasion of property. But what we'll be talking about today is a little more complicated, and that's regulatory takings. So that's when a government regulation creates a taking, even if there's no physical invasion. So courts usually look at, what's the economic impact of a regulation? Does the regulation interfere with the investment-backed expectations of the landowner? And then the character of the public action. So you may remember a few cases that come to mind, like the Penn Central case involving building above the train station in New York City and the air rights above Penn Central. And these cases all should be kind of hopefully flooding back as we start to talk about impact fees a little bit. So the first major case we're going to talk about is one of those two sister cases that it's helpful that they rhyme again, Nollan and Dolan. So in this case, the California Coastal Commission is a state agency that was set up to protect the coastal area on the west side of California. And so in order to develop new property along the coastline, in addition to all the building and zoning requirements that someone might need to go through, you also had to go to the commission and get a permit so they could evaluate how it might affect access to the coast and those other issues that are so sensitive on the California coast. And in Nollan, the property owners wanted to demolish their home and build a new one on the beach. And so the commission said, okay, well, you can build a new home so long as you grant a public easement across your property for the beach. So the easement would have been a full access easement, meaning that people could cross their property, physically walk across their property to get to the beach area. And the Coastal Commission's justification for this, they said, this easement is necessary to relieve the public burden that would arise if people couldn't see the beach anymore. If you're a taller house, the house they were planning to build was a little bigger than the one that was there already. And they were saying this new house is going to make people think there isn't even a beach there. It's going to like psychologically restrict access to the beach, which was kind of an interesting, strange set of circumstances. And the Supreme Court addressed a few things when evaluating the permit, which was challenged. The homeowner said, if you impose this condition on our development, this is a taking. You're clearly allowing this easement would impose on our property right to exclude others, and that's a taking that we have to be compensated for. So the court assessed whether or not the permit requirement or the easement requirement advanced a state interest and whether it denied the owners, economically viable use of their land. And so the Coastal Commission argued, oh, this condition makes sense because we, the view of the beach, the California coastline, this is a legitimate government interest. And, the easement requirement doesn't prevent the owner from using the land in the way they intended. It doesn't prevent them from building the house that they're looking for. But the Supreme Court disagreed. So the Supreme Court set up the first half of this impact fee conditions test we're going to be talking about today. And they said that in order for a condition of development to apply and not constitute a taking, there has to be an essential nexus between the condition and the state interest. So I mentioned a few minutes ago that the commission said there was an interest in preserving access to the beach. Visually, we can see the beach. We know it's there. We know we can access it. The Supreme Court found that interest had no connection to a grant of an easement that allowed people to physically cross the homeowner's land. So, there was no finding that the easement to cross the property was related to any purported purpose to maintain a clear line of sight to the beach. So here's a good quote from the Supreme Court. In short, unless the permit condition serves the same government purpose as the development ban, the building restriction is not a valid regulation, but it's an out-and-out plan of extortion. So again, can you have someone bargain away their property rights with no related benefit to the public? And the court said no. So the other case in our little groupings of cases today, Dolan versus City of Tigard. So this case is also interesting. It involved a woman who she owned a hardware store in downtown Tigard, and she wanted to expand her hardware store, including a new parking lot, which was substantially larger. And she wanted to, expand the size of her store as well. So in Tigard, they had a development plan that, and their zoning regulations required at least 15% of all development in that commercial district to have 15% open space. So essentially it's a lot coverage of 85%. And they also had a plan for developing a bicycle path throughout the city. So in order to get her permits and her, the required entitlements to develop her new store, the city told Mrs. Dolan that she had to dedicate a portion of her property that was within a floodplain as a public green space. So that was one of the conditions. The other was that she had to also dedicate 15 feet, like a 15-foot strip throughout the property as part of the bicycle and pedestrian path the city was planning. So in total, the dedication of the green space, the dedication of the bike path, that was 10% of her property, of that parcel. And, the Supreme Court, this is the other piece of the assessment. We talked about an essential nexus. The Supreme Court said, okay, maybe a bicycle path is related to the legitimate interest to reduce traffic. And maybe a green space is related to the city's goal to protect the floodplain and have open space throughout the city in terms of planned development. But what we can't decide is whether, there's a rough proportionality between these requirements and the city's interests. So the Supreme Court, they ended up sending this case back down to do this assessment. But what they held was that, to the extent there's a condition imposed on a property, you need to make sure that it is roughly proportionate to, the condition that's imposed is roughly proportionate to the burden associated with the development. So there's no special mathematical formula here, unfortunately. The Supreme Court always likes to announce standards that are really hard to impose. But but another great quote here, a permit condition that requires a landowner to give up more than is necessary, has the same potential for abuse as a condition that's completely unrelated. So in Nollan, the problem was that the visual access was unrelated to an easement to cross the property. In Dolan, the issue is it wasn't clear that the bike path or the green space would alleviate the harms to the same extent, to an extent that made sense under the Fifth Amendment and the 14th Amendment. So then the last background case, I know that we're spending a lot of time on background, but actually the decision in Sheets is pretty straightforward once you know all this background. But it's Koontz versus St. John's River Water Management. So in Koontz, the property owner bought some property down in Orlando. And in the same year he bought the property, Florida enacted the Water Resources Act, which divided the state into different water resources divisions so that, again, kind of similar to Nollan, the state could manage water reclamation and make sure that the natural areas in Florida were preserved. So the property owner applied to develop just about 4 acres of his property. And so to mitigate some of the negative impacts of his development on nearby waterways, he offered to completely give up the right to develop the rest of his property. He said, I just want the 4 acres, the rest of the property, which was about 11 acres, I will never touch it. I will not develop it. It won't have anything on it and it won't impact the state. The water management division countered his offer and said, okay, here are your 2 options. You can either reduce your development from 4 acres to 1 acre and make the rest a conservation area, or sure, you can develop 3.7 acres of your land, that's fine, but give us some money so that we can use it for our purposes off-site to preserve water resources. So they kind of gave him this impossible choice, and that's what the Supreme Court said. They said, you're asking him to either bargain away a portion of his property that he would otherwise be able to develop, or you're asking him to pay money for something that's completely unrelated to his development. And they said that's completely untenable. Asking him to give up 2/3 of the portion of his property he wanted to develop, or paying a substantial sum of money, constituted an unconstitutional exaction, is what it's called when it's a condition that violates the Fifth Amendment. And so the key holding in Koontz, though, which is kind of interesting, is that the assessment in Nollan and Dolan about a rough proportionality and an essential nexus applies to monetary exactions as well and impact fees. So if it doesn't matter if you're taking someone's property, you're taking a property right, or asking them to pay money, the same assessment applies. And that's when we get 2 sheets. So this is if you want to do some math, here's the table from the El Dorado County general plan. So the county requires that traffic impact fees be paid as a condition of receiving a building permit. And the formula for calculating the fee was kind of a rough determination based on the type of the development and its location within the county. So as you can see here, there are different zones that the county carved out, and then they assessed how much the parking fee would need to be to offset, presumably some, the street congestion, on-street parking, off-street parking issues, and those sorts of issues. So the Sheets family wanted to build what the Supreme Court described as a modest prefabricated home on their parcel. And this was in the low density residential district. So if you can imagine a prefabricated home and what the impact of that development, you might have a good sense of where this is going. So then the county required the Sheets family to pay over $23,000 on the traffic impact fee according to that rate schedule we were just looking at. So Sheets sued, arguing that the fee was an unlawful exaction in violation of the takings clause under Nollan, Dolan, and Koontz. So Sheets argued this $23,000 fee cannot in any way relate to the burden of my development. Look at the size of the home, where it is. This doesn't make any sense. And the county's fee schedule doesn't reflect the requirements for a valid impact fee under constitutional law. And in particular, the phrase individualized determination was thrown around a lot. He said the fee schedule was calculated based on some general averages and numbers that the county came up with itself. It doesn't take into account that my home is going to be relatively small. It doesn't take into account what kind of traffic mitigation would be required for a small residence in a low density residential district. Basically that the formula was flawed. So in the lower court decision, the California Court of Appeals didn't even consider Nollan, Dolan, or Kuntz. They didn't just even think about the three cases we just spent so much time talking about. Instead, they said that the fees did not apply, that those cases didn't apply because the fees were imposed by legislation. The county had decided and adopted that fee schedule as applicable to all properties within the county. So the court argued, you know, these exaction cases can't apply because these were implied universally by ordinance. It's not unfairly targeting one property owner. Sheep's next door neighbor would have to pay the same exact fee, presuming the same conditions. The Supreme Court weighed in and disagreed with the lower court. So again, sort of in a rare occurrence these days, they issued a unanimous decision, I think authored by Justice Barrett, that said, you know, nothing in our constitutional history, precedent, case law supports a finding that legislative impact fees are any different than negotiated impact fees. So in Nollan, Dolan, and Kuntz, and in Kuntz in particular, you know, they would have this back and forth negotiation about how much Kuntz would have to pay to develop his land in the way that he wanted. And the county had thought that was different from legislative impact fees imposed universally. And the Supreme Court just completely disagreed. They said, you know, the essential nexus and rough proportionality tests under Nollan and Dolan and Kuntz certainly apply in this situation, and there's no reason to say otherwise. You know, in this case, it's kind of frustrating. They didn't decide whether or not it met the test. They sent it back to the lower court to do that assessment. But it's good to know that if you have legislatively imposed impact fees, the takings assessment definitely applies. All right. And so we've got the Supreme Court decision. That's helpful. It's helpful for all of us to know where the Supreme Court's taken these big constitutional issues. But I also want to touch very briefly on a recent case that was decided in Illinois, because as you know, the federal court system is one thing, but Illinois law and Illinois courts are something just a little bit different. So this is a case called Hobdob versus County of Lake. It was decided in 2024. And Lake County and several municipalities entered into an intergovernmental agreement to provide construction funding for highway improvements. So the fees that were imposed by this agreement were imposed on the public and developers and were calculated depending on the size and location of each parcel. So the fees were imposed upon annexation into the municipalities that had entered the agreement. So upon, trying to annex and develop property, a developer sued the village of Mundelein and Lake County, arguing that the fees that were imposed under the intergovernmental agreement violated the Illinois impact fee law and were unconstitutional exactions. And the Supreme Court in Illinois disagreed. So this case went all the way up to the Supreme Court. And Megan and I were talking today about how that was kind of surprising because it presented a pretty straightforward set of facts. But still, it's good to have something so authoritative for our local government friends to rely on. So first, the court decided that the fees that were imposed through the IGA did not violate the impact fee law. They were based on a voluntary annexation agreement. They weren't conditioned on the issuance of a building permit or other approval. And annexation agreements, are voluntary mutual agreements between parties. It's not like a building permit could be withheld. It's not the government withholding a building permit that otherwise the person would have no right to. And then, of course, the fees were not unconstitutional exactions. So the court found that the fees had an essential nexus and rough proportionality to the government's goal to reduce congestion and improve road conditions. And then they found that the calculation that Lake County had imposed, unlike El Dorado County in California, did include an individualized determination about what burden a new development would pose on traffic. So I think that's an interesting case to kind of round out our assessment of impact fees and exactions. And that's about all I have, but we're, available for questions too.
All right. Let's see. Thank you very much. That was awesome. Really
Make everybody's head hurt on a Friday afternoon.
Yeah, Friday afternoon, everyone's taking a nap. Hopefully not.
Aaron and I have a tendency of doing crazy case law presentations on Friday afternoons. Very popular.
I did have one question, and this is back for the grants pass. You had said that there was a law passed that prohibited on municipal property. Or maybe it wasn't a law, but it was the term municipal property. I wasn't sure if that included right of way or if it was municipally owned land.
Maybe I might have been referring to one of the related hang on a second, go back. So the Bill of Rights for the Homeless or the Illinois Human Rights Act?
I think it was the Illinois Human Rights Act.
Well, so it includes places of accommodations, and places of accommodation include public gatherings and public transportation places. Yeah. So under the Human Rights Act, that prohibits access to public accommodations. And so is your question that you can't prohibit?
I was just
we've had this talk before that you've had to jump over people getting into City Hall, right?
Yes, yeah. So that was the kind of what I was thinking as you were talking about that was, if it was only municipally owned land, the sidewalk in theory wouldn't necessarily qualify for that because that'd be public right of way.
I think the takeaway from everything that's going on with the pending House bill and the cases that have come out is stay away from criminalizing, because that's the proposed House bill legislation is that you can't criminalize any of the anti-camping ordinances. You can remove people and you could make there be civil fines, kind of like where the marijuana legislation went, but it can't be criminal. And you also can't enact fines, which that is the opposite of the marijuana legislation. But what you could do is essentially you could just be removing people, but under the proposed legislation, you'd have to be giving notice. I think that if the legislation that's proposed doesn't go forward, you have the right to move people from public spaces. But you have to be reasonable about where they are in relation to people have a right to be at City Hall. They can't be on the front steps if they're impeding somebody's ability to get to City Hall. You have a right to follow, for example, with our Park District clients, most of them have enacted anti-camping ordinances that say you can't be in our parks after sunset to sunup the next morning. So they have the right to remove anybody who's there after hours. Does that apply the same to somebody who's camped outside of City Hall? Probably not. But do you have anti-loitering ordinances get a little tougher to enforce too?
Yeah, I think it's like there's such a weird constellation. It's very difficult I do a lot of First Amendment work. And so when I think of anti-loitering or some anti-panhandling laws, I'm like, oh gosh, that sounds off an alarm in my head about the First Amendment. Yeah. And then there's the Bill of Rights for the Homeless Act. And it's very difficult to draft regulations and enforce them even-handedly to say this has nothing to do with the person being unhoused. Because ultimately a lot of regulations do disproportionately impact that population because, who else might be camping in the park, and so I think it's really difficult, but I think Megan's right on point saying that there are like procedural protections that you can take notice regarding people's property and removing it. And I think probably a conservative, like lowercase c approach to some of these issues is probably for now until we see where this legislation goes. I don't know, Megan, if you agree, that's kind of where it has to be.
Yeah, I mean, the Grants Pass case says it's not a violation of cruel and unusual punishment to make it criminal. However, Illinois has in place so many measures that protect homeless populations. And so I think, I'm not going to criticize IML's ordinance. However, I think that you have to be careful in enacting an ordinance and thank you, Paula, for sharing the link to that, because it does get you, it could get you into some federal civil rights arguments as well as Illinois human rights arguments.
Yeah, because the IML ordinance too it mirrors the Grants Pass ordinance almost exactly. And I was one of the attorneys who like read both side to side, and they're very similar. And so I think justifiably, that's a great ordinance to avoid any Eighth Amendment problems. It's not cruel and unusual, but I'm not, given that it was passed originally in Oregon, we don't, their state laws are different. The Bill of Rights for the Homeless Act is probably the law that I've cited the most to say, like, read it and reread it and be careful and make sure your ordinances and regulations are, if not, facially, they should be neutral, but also when you apply them, what populations are you enforcing them against really is kind of the key issue.
I think the other thing I heard you guys say was you really need to focus on if there's criminal behavior associated with it. So public urination, indecency, going into a neighboring business and panhandling inside the business. And I guess panhandling, asking more than multiple times for, Nimrod, did you have a question?
I did, yeah. So I didn't know if these factors would be even something to bring up or worthwhile to consider. Weather, temperature, or the surface type or topography of the area for which their encampment is on. Because if it's a safety concern from any of those perspectives to remove people from the properties.
But are you rescuing them from themselves or?
Well, no. Well, the liability. If somebody gets injured on your property because they went onto a steep cliff area that's on the backside of your property that overlooks a ravine, you're going to be liable to a lawsuit if they get injured themselves?
Well, that's why we have the Tort Immunity Act.
Well, I guess.
Well, and I think too, the question it becomes in that case, how do you enforce it? Do you remove their encampment? Do you remove their tent? Or do you give them an alternative place to go? And that's always a really tricky question because it's one thing to say, okay, this steep slope is not safe. Maybe find another place. It's another thing, like Megan said, there are huge, Fourth Amendment and Bill of Rights for the Homeless Act implications for going in and seizing their property. And that's a really touchy subject for sure.
I will say along Nimrod's point, one of the areas that attracts a lot of folks is a little like vented area that vents hot air in the winter or like warm air. Mm-hmm. And there is some concern that maybe the exhaust from whatever is coming out of that vent is not safe for people to be like breathing all the time. But there's also concern that if the vent isn't working properly, there's damage to the building. But that's kind of a separate issue. Again, it's not necessarily the encampment that's an issue. It's maybe the location or one of the ancillary impacts of that encampment, which you're then regulating the impact, not necessarily the encampment.
Yeah, there's no easy answer to this. And I think the problem was that pre-Grants Pass, we were kind of stuck with this Martin decision that left governments even fearful of taking any action. The Grants Pass decision at least gave local governments less of a fear that they could intervene, whether it's even just to suggest and recommend solutions, because Martin left them feeling that they were going to get slapped with an injunction for taking any measures. So like we've repeatedly said, it's a very limited decision, but it does give you local governments and enforcing agencies seems to be the term that's thrown around more recently, a little bit more weight in making decisions that they can enforce ordinances to keep their own patrons safe and for public property sense and enforcing their ordinances, where prior to Martin, I don't think they felt like they could even do that. So.
All right. Well, I'm looking at the clock. Looks like we're past 4 o'clock. I don't know if Scott has any closing remarks, but I would say just again, thanks to Megan and Aaron for taking their time to present to us. And I found it really insightful and thought-provoking. So appreciate you guys doing that. And I don't know, Scott, I guess also you guys had your contact info in the presentation. So if people have follow-up questions, they can always reach out, and Ansel Glink's always willing to take on more work, I'm sure.
Absolutely.
Thank you, Megan and Aaron, and thank you to the American Planning Association Illinois State Section. Very important session, some important cases discussed, and look forward to helping local governments manage the impacts of these decisions going forward, and seeing what else the U.S. Supreme Court has for us in their forthcoming decisions. Usually come out in June, in July. So we'll be hearing some more news from them soon, I expect. But before we go, I want to remind everyone to subscribe and leave us a review wherever podcasts are heard. We prefer good reviews. Email us your questions and show ideas at podcast@anselglink.com. You could always leave us a voicemail on the Quorum Forum hotline, 312-604-9178. And you can visit us online at quorumforum.anselglink.com. Can we get a motion to adjourn? So moved. Second, all in favor. The ayes have it. We'll see you next time on Ansel Glink's Quorum Forum podcast.